So, no, I wouldn't say I have a passion for HR.
Welcome back to Human Resources for the People. It's a human capital revolution. Today we're going to be talking about hiring someone in Switzerland. This is part of my ongoing series about hiring and firing across the world. It's something that interests me quite a bit because comparative human resources is really interesting. It's good to see how other countries do it besides the United States. I've dug into countries such as Iran, China, Venezuela, and I think those are always really intriguing for me. So let's get right into Switzerland, which is surprising, I think. So the first one is whether or not there's a question about prohibitions against background checks on applicants. This one I really love, and it's if an employee is or if an applicant is currently working, the current employer can't be contacted without applicant's consent. I mean, that of course happens in the. I don't think it's prohibited in the United States, but it's definitely asked, right? I don't know if I've ever seen a lawsuit come about as a result of not giving consent. Just like in the United States, there's a question of whether or not employers should look at social media when considering their employment relationship. There is not clear case law on this, but there isn't a clear demand from the Swiss government. Again, consent is asked for when there's a psychological test involved, but it's just like in the United States. I mean, they always ask you to give consent, but it's not required. The interesting thing is that they do make sure that you give answers relating to health conditions truthfully, if it's necessary to assess the eligibility for the position. In addition, the applicant's suitability for the employment relationship from a health point of view can require an examination from a doctor, but that doctor is, of course, bound by the duty of confidentiality, no different from the United States. And if the medical data is necessary for final assessment of an applicant, employer can refrain from hiring if the examination is refused, just like in the United States. Some of these laws are not particularly groundbreaking. In fact, I find that Switzerland, in many ways, appears to be very similar to the United States. The same with their drug tests. Applicants can undergo drug and alcohol screening if the results of the test are necessary to assess their eligibility for the job. And so, I think that is pretty clear. It's pretty much the same in the United States, although I guess eligibility is up for debate. If the applicant doesn't give their consent, they cannot be forced to take the test, but the employer can, of course, refuse to employ an applicant who does not wish to be tested. With respect to hiring and discrimination, most of the things apply just like in the United States. Although I will say that there's one that's kind of interesting. So you cannot discriminate on the basis of race, origin, some national origin, language, mental or psychological disability, social position, religious, political, or ideological convictions, or gender. In the United States, political or ideological convictions are not, as well as political, are not part of the deal. As well as social position. There is no specific case law on that, although there could be some arguments there. I will note that this one, they cannot only discriminate based on mental or psychological, but in the United States, it's also physical. And so I think that that's an interesting concept. Of course, the Federal Act of Gender Equality requires that employees do not discriminate based on their gender, and that includes marital status, family situation, or pregnancy, similar to the United States, and does give the option of, taking action when that happens. Of course, in many ways, the discrimination concept inside the United States is the only supreme labor law, and really the basis of all labor law is anti-discrimination in the United States, or not all, but a huge portion. American labor law, with respect to the protections of employees, is predominantly focused on discrimination and not anything else similar to the rest of the world. Employers are not even required to do a employment contract, although they are common, and it's a written form is the only valid one for many. But once you start work, there is a written information letter that talks about the two contracting parties, the employee and the employer, the date of when they started, the function of the employee, the salary and wage supplements, and the weekly working hours. This is not required in the United States, of course, and I'm not sure what the value is of it. I mean, it's similar to an offer letter, but offer letters are, of course, not required in the United States. There are requirements surrounding probationary period. There is no probationary period required or permitted by law in the United States. You could, in theory, have a 2-year probationary period, but in Switzerland, the law is 3 months. You can extend it, and if it is interrupted by illness, accident, or performance of a legal obligation, it will be extended, which makes sense. These probationary periods give employers in the European Union and throughout the world the ability to terminate employees that are not a good fit ahead of time before it's called out by their contract. It's important to understand probationary periods, especially throughout the world and outside of the United States. Of course, like much of the post-colonial world, there is legislation with respect to temporary staffing. There is control over recruitment agencies, and they actually have an act, the Federal Act on Placement Agencies and Staff Leasing Services. This is pretty interesting. They have a lot of controls with respect to this in Switzerland. They actually have to be granted authorization from the authority, which is the canton's employment office, which I find to be really interesting. I'm surprised that this is, such a difficult situation compared to the United States, where there is very little governance, and temporary staffing acts very much the same as any other company acting in their own in their own stead, right? So I think that that's really interesting. They can't send services of personnel into Switzerland by an employer domiciled abroad. I think that's interesting as well. This is an interesting, very surface level view of the Swiss uh, employment law and human resources practices in the country. Let me know what you think in the comments down below. I'll leave a link for this article as well as some of my other videos on the same subject, and we'll see you on the next video. Bye, guys.